and being told we're running a little bit late. So let me just go on and make a couple of introductory comments if I can. First of all, it was enormously interesting to hear, am I on the right thing here? Sorry. Enormously interesting to hear the proposals for legislation in this jurisdiction, but also for those of us who are in practice in the UK, the two studies that were spoken about this morning, the study of Professor Gollenbach and the study of Dr. Horsey from Kent, are very helpful because the mapping of the statistics and some of the myth busting is very useful when you're in practice to get a wider academic perspective. But I wanted to make a couple of comments by way of introduction before going on to look at the law in the UK and how it operates. Firstly, my perspective is very much a practitioner's perspective, and as a practitioner in this area you get really two types of cases. You get the ordinary straightforward cases, which make up about half of the cases, perhaps more than half of the cases that are going through the courts. And those cases in the UK are decided at the lower level courts in the magistrates, and they're reasonably straightforward administrative processes. But the other kind of cases, the cases that make the press and the cases that we're going to talk about in this paper this afternoon, are cases where things go, unfortunately, horribly wrong. And so it challenges, I think, the parameters of the law and the legislation and presents real dilemmas and difficulties for judges. When we talk about the utility of the UK model, when you're looking at a process in this jurisdiction about trying to draft legislation, there are, I think, from a practice perspective, some really useful lessons to be learned from the UK model. But in general, I would have to say, as a practitioner, the UK model works. The parental order model works. So that would be my opening perspective. And I'll go through some of the reasons why I think it works and some of the reasons why I think it may need some modification. What we have to be very careful about when you start to redraft legislation and when you're drafting, as you are in this jurisdiction, legislation from scratch, is I think there has to be a recognition of the wider concerns of the public about circumstances in which children are conceived and arrangements that are made and difficulties around commercialisation and commodification and so on. And those difficulties means that there has to be, I think, some sensitivities to other areas and other consequences. So, for example, if we start to create circumstances where the gestational mother is not the legal parent at birth, what are the consequences of that in other contexts? And I think those are issues that, particularly in the UK, have been the subject of a lot of concern and a lot of questioning. One other point I wanted to make by way of introduction, and then I'll go on to have a look at the law, is that there's a terribly irresponsible coverage, I think, of surrogacy by the press. And the way in which surrogacy finds itself reported in the UK is always the kind of weird and wonderful surrogacy case. The surrogacy case where there's a very unusual arrangement, perhaps between the parents, the surrogacy case where the surrogate refuses to hand over the child. And all of that, I think, creates this idea of surrogacy as something which is somehow sort of stigmatized, it's a bit odd, it's not something that ordinary people are going to do. And that, to me, as a practitioner, is very wrong, and it's very unfortunate. The vast majority of people who engage in surrogacy arrangements are, for want of a better word, very ordinary, very normal people. But what is striking is that you get, and this I think is backed up to some extent by the Kafka stats, you get couples who have been through a range of difficulties to conceive and to have a child. And so one of the points I think that Kirsty made earlier and Susan Gollenbach made is you're seeing couples who really want to have a child, who have made great efforts to have a child, and who have invested emotionally and psychologically an enormous amount of energy in having a child. And the real sort of point for legislators and policymakers is to bear in mind that if you don't regularise surrogacy, if you don't create a legal framework which works for surrogacy, then you end up with circumstances where parents are pursuing surrogacy, where children are being born as a result of surrogacy, and there are huge difficulties then over legal relationships and the status of the child and the status of the parents. So there's a moral imperative, if you like, to create a legal framework which operates and which works. And in my experience, representing individuals in surrogacy, I've acted for commissioning parents, I've acted for surrogate mothers, and I've acted for the children in those arrangements. There's a need for a resolution, and people are very keen to resolve legal relationships and to find themselves at the conclusion of the process in the same position as other parents. So those are a couple of comments that I would make by way of introduction. Let's go on then and have a look at a number of aspects in relation to the UK legislation. I'm not going to go into much of this in great detail because I think Kirsty has touched on this, but I wanted to just outline for you the UK legislative framework and to flag up some of the difficulties or the challenges that have arisen. Then I'll talk a little bit about the legal effect of parental orders, and one of the reasons why I think parental orders are such a suitable model is that you end up with the commissioning parents or the intended parents being the only legal parents of the child, and that's quite important. The Section 54 conditions have been the subject of a huge amount of criticism. One of the things I would say about that is we're very lucky in the UK that the judges have been enormously creative about resolving the difficulties. So while the Act itself may not be fit for purpose and while the Act itself may be somewhat outdated, we have a growing body of case law which is solving the difficulties that are arising in a very creative way. And when one looks to developing legislation in this jurisdiction, the case law and the interpretation of the Act itself seems to me to be quite important and something which I think will continue because of the specialised nature of the tribunals. And then we'll look at the limitations of the legislative framework and what I have rather grandly called new dilemmas, but it's just problems and difficulties that have arisen. All right, so very quickly just to run through and remind everybody what is surrogacy. Well, under UK law, surrogacy is an arrangement whereby gestational mother agrees to carry a child for commissioning parents, but she is not the intended parent herself. Surrogate agrees to hand over the child at birth, and the arrangement, of course, has to be pre-birth. If it's post-birth arrangement, then it's a relinquishment for the purposes of adoption. Difficult issues under UK law, and it's interesting to hear Brian Tobin's comments on the proposed legislation here. One of the big issues under UK law was whether or not it was necessary or important to have a genetic relationship between the child and the surrogate, whether or not you were going to have host surrogacy. And I want to talk a little bit about that later in the discussion. And then the idea of the legally enforceable or legal contract that you have in surrogacy. We know under the UK legislation that that is not the case. So we have two main pieces of legislation in the UK. One is the 1985 Surrogacy Act. 1985 Surrogacy Act is top 5 piece of badly drafted, reactive, media moral panic piece of legislation. Dreadful, dreadful piece of legislation. Motivated initially by motivation is probably the wrong word. The genesis for it probably comes from the Warnock Report and a concern within the Warnock Report about commodification of children and exploitation. But one of the driving factors was the Kim Cotton case in the 1980s, and that led to a very poorly drafted piece of legislation. And then we have the Human Fertilisation and Embryology Act. That's an act which is about a whole range of issues, and surrogacy or parental orders were sort of shoehorned into that act at a very late stage in the legislative process. Key element, of course, of the UK law is its reactive nature, and the consequence of the reactive nature meant that you ended up with this rather ridiculous situation where commercial surrogacy is prohibited, assisting parents and taking fees and funds for assisting parents, so agents, paid agents, are prohibitive. Surrogacy arrangements are not enforceable, but in a typical sort of compromise, surrogacy itself is not illegal in the UK. And so you have this odd lacuna under the legislation, which has led to some real confusion. A couple of things I just wanted to mention to you about the 1985 Act. The 1985 Act is generally thought or seen as somehow stigmatizing or quasi-criminalizing surrogacy. The real difficulty, I think, with the 1985 Act is it means that parents who are looking at surrogacy arrangements cannot enter into legally enforceable agreements. And it seems to me that it's fundamentally problematic that that cannot happen. It's less important as to whether those legally enforceable agreements are commercial in nature, but the fact that all of the players in the drama cannot get the sort of advice that they need and set down in writing something which is then binding on all of the parties is what creates a lot of the difficulties. Recently in the UK, CAFCAS, which is the state agency which represents children in this process, has published some statistics, and I know that Kirsty's group have raise some question marks about the accuracy of those statistics. But they're helpful in a very crude sense, because what they tell us is the number of parental orders. In other words, who are surrogate parents and who are making the applications. And what we know is this increase from 56 applications in 2007 to 213 applications by 2012, and that had risen to 241 in 2014. Bear in mind, of course, that is only people who are applying for parental orders. There will be a whole range of others who don't make the application. I thought quite an interesting statistic from CAFCAS was that 44% of applicants for parental orders in the final year of the CAFCAS study were international arrangements. And I think that fits in with what Kirsty referred to as the transactional nature, that the conclusion of the transaction is to obtain the parental order. And then there's the figure about 78% of the applicants for parental orders in that particular year being heterosexual and 22% being same-sex couples. You'll have picked up from the discussions with Brian and the discussions with Kirsty this morning that the framework in the UK is that the gestational mother is the legal parent. And the purpose of the parental order, and one of the reasons why I think it's a very useful model, is the purpose of the parental order is to transfer legal parenthood from the gestational mother to the to the commissioning parents. You can, of course, and in many cases you do, of course, have the genetic father on the birth certificate. So the genetic father is very often in a position of being a legal parent from birth. Very often the primary purpose of the parental order is to transfer legal parentage to the commissioning mother. And then the effect of it, and this is why I would say that it is a useful model, the effect of it is the same as adoption, the legal effect. So it means that as a consequence of the parental order, the commissioning parents are the only legal parents of that child. And that is extremely important in terms of regularisation of the child's status and position. In the UK, that is achieved by way of the parental order register, which is similar to the adoption register. So after a parental order is made, the Registrar General is provided with a copy of the order, and there is then a parental order register which registers the change in the legal status. And crucially and importantly, child is then treated for all purposes as the legal parent of children. Now, one of the things which I think is potentially very difficult and is going to give rise, I think, to some difficult case law in the future is there are parents who are commissioning children through surrogacy and not obtaining parental orders. And there's a whole area of case law that we will at some point see where there are difficulties about contact with children, inheritance, and so on and so forth. But that particular little nest of wasps hasn't made its way to the court as yet. Okay, so let's go on then and have a look at areas of difficulty. Areas of difficulty I think that we have in practice, and which I think have given rise to some of the cases, is there's no arrangement in UK law for screening of donors, and there's no arrangement for screening of surrogates or assessment of surrogates. When, of course, surrogacy works and it ends up with the sort of relationship that Susan was talking about earlier, sometimes between surrogate mothers and parents, that is obviously the ideal. When it doesn't work, it creates all sorts of pressures, and usually, unfortunately, people end up spending a few days in court with someone like me and trying to resolve the difficulties. And I want to take you through a case which illustrates many of the examples. The other point, of course, is that there's no legal requirement for intended parents to make provision for children born to surrogates. So, for example, if the intended parents or one of the intended parents dies during the currency of the pregnancy, that's a potential difficulty. And then, of course, we have the problem of no binding contracts. What is not surrogacy? This is a case which I think illustrates everything that could possibly go wrong in a surrogacy arrangement. I acted in this case for the surrogate mother, and this was a case that came to the courts last year. It illustrates something which I think is fundamentally flawed in the UK process, and that's the ability to get proper legal advice and assistance in advance of embarking on a surrogacy arrangement. The parents in the case were a UK couple. The wife had had some very significant fertility difficulties, and as a consequence they decided to embark on a surrogacy arrangement. Through their community, the wife was from a West African country, and through her community She was linked up with an extremely dodgy agent, or a sort of described himself as a sort of do-gooder, but he was a very dodgy agent who put them in touch with my client, who was an exceptionally economically disadvantaged woman living out of the jurisdiction in Germany. They entered into a surrogacy arrangement. They agreed to pay her €2,000, which, as you can see, was a really quite minimal amount of funds. They had been advised to have artificial insemination, and then at the last minute, they had been advised by the dodgy agent that that would not be recognised as a surrogacy arrangement in Germany, where the mother was living, and so the child was conceived naturally. And the surrogate mother then handed over the child, family returned to the UK, and then there was a falling out over money, and the surrogate made an application under the Hague Convention. It was an extremely tragic and unfortunate case. It ended up in a 5-day hearing in the High Court, which was about the Hague Convention, had the parents unlawfully removed the child from Germany, which of course they hadn't. But what was behind it was a surrogacy arrangement in which nobody had had proper advice, nobody had been able to get proper assistance, and there was an illegal agent in the middle of it. And one of the things, the catalyst for the dispute, was that the surrogate mother discovered that the agent had been paid quite a bit of money, and she herself had not been paid a significant amount of money. I didn't think any of these arrangements, in my experience, are ever about money. This was a woman who was very disturbed and upset about being badly treated, I think. But it became a dispute about money. And at the conclusion of the case, they were not able to get a parental order because she would not consent. They ended up getting a residence order out of it, and she ended up getting a minimal amount of contact. But it illustrated, I think, everything that can go wrong about people not being able to get proper advice in advance and not being able to get some sort of enforceable arrangement. Okay, I'll very quickly run through the conditions and then look at a number of illustrative cases. The conditions in the UK Act, well, before looking at the conditions, just to remind you, the way the UK Act works is Section 54 sets out a series of conditions. The court has to be satisfied the conditions are met, and then the second stage of the process is the best interests analysis. This is in the child's best interest to make the order. One point I would make in the sort of creative thinking that you see in the High Court or in any court, if the best interests principle is in the Act, then what you're going to find is, in most cases, even if the conditions are not met, there may be a best interests imperative for making the order. And that's a very important part of the process. The other point I would make is there is some critique of the conditions. And I think it is a less than perfect process. But one can understand that there has to be some conditions. There has to be some process whereby you decide whether or not somebody meets the criteria for the order. So these conditions may be somewhat outdated and not fit for purpose, but they're very much altered by the case law. So the conditions are these. One of the intended parents must be genetically related. In terms of surrogacy in the UK, and Kirsty will correct me if I'm wrong about this, but I think it's about half and half in terms of host surrogacy and traditional surrogacy. I think it's moving more towards host surrogacy away from traditional surrogacy, but traditional surrogacy, the surrogate herself is related to the child. Application must be by a couple. That is a big issue in the UK. Can the application be made by a single person? At the moment they can't. The application must be within 6 months of birth, no earlier than 6 weeks. I'm going to talk very briefly about a case where that has been set aside. The child's home must be with the applicants. That, I think, is with a view to the overseas surrogacy primarily, that if the child is out of the jurisdiction, the order cannot be made. And then the consent of the surrogate must be freely given. That piece of, that condition in the Act has been the subject and is about to be the subject of another challenge, and I'll talk about that very briefly. And then no money other than reasonable expenses are to be given to the surrogate. That is really sort of comedy value condition, because in reality, the reported cases, the highest figure in reported cases, $56,000 US, but I'm aware of a case in which there was $96,000 US, and it's not a reported case. There hasn't yet been a case in which the court has said this figure is too high and does not constitute reasonable expenses. So that's a sort of elastic provision, and I'll come back a little bit to look at one of the cases around that. Okay, let me move on then and talk about some of the case law. I want to just go through a number of cases that illustrate, I think, the creativity in the court. One of the difficulties which arose in a case called AA versus PP was if we look at the surrogacy conditions in the Section 54 provision of the Act, one of the surrogacy conditions is that the child has lived with the parents. In this case, I acted for the child in this case. And this case raised a really difficult dilemma, but the court used it to make some very important observations about surrogacy, which I think have had a knock-on effect into other parts of the case law. The case involved a couple who were married. They embarked on a surrogacy arrangement in India. Child was born and the couple made the application. They returned to the UK with the child and made the application in about June. Rather tragically and horrendously, the male member of the couple became ill and he died in December of that year. So between the application being made and the order being made, he died. And the question in the case was whether or not you could make a parental order to a deceased parent. And what was interesting about this case was that he was the parent who was genetically related to the child. The wife was not genetically related to the child. And the argument that we ran in this case, which found favour with the court, was that you had to look at the 2 minutes. You have to look at the nature of the order. What is the purpose of the order? And the nature of the order is a transformative order. The purpose of it is to secure the identity of the child, the link of the child to parents. And that justified, we said, looking at the Human Rights Act, the relationship, the family relationship between the child and the parents. So even though the father was dead, it was important to the child's identity that the child had a legal relationship with the dead father. And the only way that that could be achieved was by way of a parental order. And so the judge arrived at a very creative solution where she said the provision in Section 54, which required that the child live with the applicant, could be that the child had lived with the applicant. So while the father was alive, the child had lived with the father, and that was sufficient for the purposes of the Act. But the significance of AAPP was the focus of the court on the transformative nature of the order and the focus of the court on the concept of identity. In other words, that identity rights of the child drive the resolution of any conflicts around the conditions. And that judgment was used, I'm going to come back in a minute very quickly in 30 seconds to the issue of expenses. But that judgment, the AAPP judgment, was then used to set aside the 6-month rule. So in the 6-month rule, what you had was parents making an application 2 years after the child was born. The court initially saying, well, we can't make a parental order because it's outside of that particular condition. And the president of the family division went back to the decision of AAPP and said, well, what's the purpose of this process? And the purpose of the process is to transform the nature of the legal relationship. The identity rights of the child require that there is a parental order. And a time limit was an entirely disproportionate provision in that context if the consequence of it was that the child would then have to go through life without having that transformative legal relationship. So that argument, I think, has sort of opened a door to challenging the various conditions. The last point I want to just mention very briefly is the cases about expenses. There's a very pragmatic approach taken to the UK, in the UK courts about expenses. And there's a sort of odd sort of dance that is done between the court and the applicants, where you sort of write out for the court what the expenses were comprised of, and you'll have sort of vague figures, for example, like £26,000 for discomfort and, various different sort of sundries, and there's a big sort of figure, and the judge is looking at it and saying, okay, well, that's 26,000 for that, 10,000 for that, 5,000 for that. And I'm sort of making light of it because it's extremely difficult to actually itemize what the purpose of expenses are, particularly where you're looking at an overseas surrogacy. And so the court generally will want to be sure that the will of the surrogate has not been overborne. There's some guidance given in the case law. But it will not refuse an application on the basis of expenses. There may come the day, but it won't. And then the very, very last thing, and I think I'm over my 2 minutes and into my third minute, but the very last thing I just wanted to mention to you is the issue of consent, Brian has raised the issue of consent. It's a cornerstone of the UK legislation. Where consent has arisen in the UK is in two contexts. One is in overseas surrogacies, where very often the consent was evidenced in a very poor way. So, for example, in some of the Indian surrogacies, which arose in the WT case, what you had was a form signed by the surrogate in English, and in the WT case, there was no evidence that the surrogate could read. There was no evidence that the form had been translated for her. And so the judge required the commissioning parents to get a lawyer in India to advise the surrogate and to get a notarized document to say that the consent had been translated, that she had signed it giving her fully informed consent, and that it was then accepted by the court. But the other consent issue which may potentially arise, and I was interested in Brian's observations on this, the other consent issue which may potentially arise is where there's a difficulty about capacity or cognitive functioning. There's a case in the High Court at the moment where the surrogate mother has a cognitive impairment, and the question which is being raised by the commissioning parents is whether she had the capacity or was capable of consenting. And then if you have this argument, and I don't mean capacity in the sense that she lacks legal capacity, but was she intellectually able to understand the consequences of the agreement that she entered into, and if you say that she was not, then you get into this very unattractive set of circumstances where you override her consent or you circumvent her consent. There's no mechanism for that in the UK process, but from what Brian was highlighting earlier, there may be a process in the proposed Irish legislation for dispensing with consent. If the model or the comparator or the analogy is adoption, under UK law, of course, very controversially, you can dispense with the consent of a parent. And there's a school of thought, certainly among practitioners in surrogacy, that there may be a case in which it would be appropriate to dispense with the consent of the surrogate. And so that weird and wonderful case, no doubt, will make its way to one of us, I'm sure, at some point. But the case about the cognitive functioning is going to be heard in April. I think it's going to be an enormously difficult and very controversial case. I think I've gone about 6 minutes over my time, for which I apologise. Thank you very much.